Hello, everyone, and welcome back to VectoScalar Tech Talk show. In this show, we invite thought leaders in the tech space to share their experiences with our audience. In this episode, we have Dr. Agalya V with us. To introduce you to the speaker today, she is Professor and IIC President, Head of IPR Cell at New Horizon College of Engineering with more than 19 years of experience. She has received Ph.D. in Electrical Engineering from Anna University. She has published 25 plus research papers in CSI and Scopus Index journals. She has 5 Indian granted patents and 7 granted industrial designs. In the same regard, she has received numerous awards for her great work, and some of them being Women Tech Maker Ambassador from Google India in year 2023, Best Performer recognition for being an innovation ambassador during 21 and 22, and there are so many such awards. In the meantime, we have Dr. Agalya with us. May I know from your experience that what is your current understanding of IPR? That what is IPR and how does it work? So do share your thought process in the chat box below. Also, in case you have any question for us to share, and I'm sure you must be having interesting insights and questions for Dr. Agalya, do share those questions in the comment box below, and I'll be taking up those questions gradually. So let me invite Dr. Agalya to show. Welcome, Dr. Agalya, to VectoScalar Tech Talk.
Good evening. Yes. Good evening, Mr. Vikas. Thanks for inviting
Thank
me for the intellectual property rights and technology related to software field.
thank you. Thanks for being on the show. So let's first understand what is intellectual property rights, because not many are aware about exactly what does it mean. So do share those insights with us, ma'am.
Intellectual property rights, we have, everybody's we have an property, and it should be in tangible assets. But the softwares and the books and the copyrights, manuals, everything, it may not be destroyed. Though the inventor is no more, still we are using the same thing. So we can call in a single word intangible assets. Intellectual property rights are intangible assets.
Okay, that's interesting to understand that. Okay, these are the particular intangible assets. So in the technology space, could you give us some examples that what kind of intellectual property rights that usually founders should be aware of?
In the software field, there are seven category of intellectual property rights, but especially in the software field, they must be aware about the four types. One is a patent. The other one is each and every softwares are operated with a different kind of programmings, and then there will be and features will be processed through a program. So there will be a copyright for the manual of any kind of a softwares, or then trade secrets. So if you want to create in a medical field, we are creating much medicines, so many healthcare applications. So there are formulas, we cannot disclose everything to the world. So that secrecy should be under in the trade secrets. And then the trademarks. If suppose the company A want to create a logo or a symbol or any kind of taglines or new name of the company, that will be comes under trademarks. So there are four variety of types intellectual properties the software persons has to know.
Okay, that's four
I hope I
things,
answered for your
including
question.
patents. Yeah, yeah, for sure. So starting with
Yes.
patent, then we have copyrights, like we have for the any kind of books or any kind of innovative content that someone is writing. So in the similar manner for the programming, the trade secrets and trademark. Like now, before
Yeah,
moving forward, I would
exactly.
like to understand that how you transition into this field, because it's not a regular kind of work that people are doing. So, what was your journey and how you transition into getting into the IPR?
The thing is that during pandemic time, everybody's are facing with the health crisis. And then
Yeah.
so I lost my family member also, so he's my close
Oh.
my brother. So he's no more. At the time I understood, so many medical issues are we are unaware. So if we protect some kind of a devices useful to the society, exactly on the everybody's are going for the invasive methodology, but in the middle families they are unable to invest huge money for that. So low cost with effective solution, and the devices will be easily accessed by the people. So we thought of producing an non-invasive device for the cholesterol identification. So this is my first invention. So after that we are getting into an continuous field. I switch over into an intellectual property rights head, and for the past 5 years I was heading this innovation and entrepreneurship and produced more than 800 patents to the institution level. And personally I have around 18. So these are the story behind that. So each and everybody's it is simply we can say the quote from Einstein. It is an innovation is an individual responsibility. It is not for an R&D people.
That's a very probably a soft kind of story, in a manner that kind of an inspiring story, that you had a personal experience. So it did not start from a typical what you call the educational kind of thing, that kind of transition. It started that you had some personal experiences, you want to create an invention, and that invention got recognized as a patent, and then you started imparting that knowledge to others as well, that how they can also innovate and create those things. But Dr. Agalia, still in many people mind, it's a phobia kind of thing, that it's a too much work to do, creating invention, how to do those things, how to write patents. Is it that difficult to actually patent your
No,
thing or create a copyright thing?
it is not that tough. So when I started my first draft, I thought it is very difficult. But the patent examiner who is going to evaluate our ideas, they are not at all expecting an high level English. So whatever the content we want to be deliver in front of them, as much as simple we can explain, even though it is on one page or a 10 page, that doesn't matter. So information should be very clearly and precisely we have to be elaborate in a detailed way to them. So this is what their expectation.
Okay, so that means that
Yes,
everyone and
they
anyone
are
can at least think
given
of it.
formats as a manual.
Okay.
Yeah, yeah. So they have provided the manual in a detailed way how to draft from the starting to the till end of the abstract. So how much content and what kind of things to be included there, they have clearly mentioned in the manual itself. So as the individual, we can go through first the patent office manual, and we can try a samples. Then after that, you can submit at least one. So file an FER, get the questionnaires. If questionnaires are extending up to 10 pages, then you can drop out the plan. If it is within 4 pages, then it is easy to manageable by yourself.
So when you win questionnaire, the cross questioning that are coming up for you to answer, is it?
Yes, yes. So it is answerable by us, and there are three things we need to be checked before going to file and patent. One is the idea should be worldwide new. So if it is no novelty is not there, then there is no there are yes or no answer. So three categories: one is novel, then other one is non obviousness, then useful to the industry. If these three are met as yes, then definitely your idea is useful to the society, so you can get a grant easily.
Okay.
So
So
before
it does not mean
processing
that
an
one has to write a
application, you
very
must pass.
detailed plan or has to be an industry expert first before writing a patent. It's not the case, right?
Yes, yes. Every individual we can try.
Okay, that itself is very hopeful, that at least we can try, and whenever novel thought that we are getting, we can at least try, study the manuals and work towards it. Now, Dr.
Exactly.
Agalia, there is one more observation, that sometime startup founders, especially tech founders, are so involved in writing the code, building their product, or then getting the customers, that they sometimes take this IPR thing at the secondary level or tertiary level. They don't prioritize it much. So, could you share some, in case with your experience, you might be knowing some major case studies where IPR issue led to a major challenge for the company and showing the importance of doing the IPR work at right time?
Exactly. So the first condition is all the startups, those who are started, we need to make the products inside India. That is a logic created by a Modi ji, make in India, made in India. So startups, they must to have an IP. This is the first condition. So if doesn't have an IP, within 1 year, they have to be go for a protection of their invention or the process. So this is a condition for all the startups. Suppose if they could have failed it in protecting an IP rights, one year there is no issue. They will be concentrating on only for earning the money. The second year, the market value is keep on increasing. So they need to be modify the add-on features with the existing process or the product. So they need to compare with the competitor. So if the competitor is protecting an IP rights, they are not filing any IP. At the case, definitely they will be calling for an infringement. So that you can see many cases are going on nowadays, especially in the mobile communication, and then even the service. Many applications, similar kind of a services are available. So who is having an additional features and protected with IP rights, they doesn't have any problem in future of 20 years or 30 years, whatever it might be. But the thing is that once the infringement comes, if parallelly X company and Y company is going smoother manner, doesn't matter. But if it is any profitable and they are facing any loss, then only the company will be fight each other and they will finding and loopholes to file a case in that way. So I'm suggesting software companies or the product manufacturing industries, they can protect their invention with the additional small features with the existing processor products.
Okay. And how do we define the product? Because in some cases, for especially the hardware industry, where the end product is quite visible, but I have been
Yes,
in
yes.
so many discussions where people are saying that okay, it's just an idea, nothing can be produced out of it, so it's not a patent. You can just file a copyright for these things. Now, being into software, like how will one decide? For example, somebody is using e-commerce, and now other companies also doing e-commerce, but what changes they will see, if there is any example that okay, probably one or two example in IT, if you can give us that okay, this became a trademark or patent, not a trademark. My first question will be regarding the patent, that this become a patentable thing.
Yeah. So first of all, the patentable inventions are, they will identify the three categories. One is the idea-wise novel. If it is simply an idea, there is no process or a product created by the inventor. The first step itself, they will be rejecting. And the second one, simple example we can take. Mobile communication is the best one. Oppo, Samsung, and all other started from Nokia and other manufacturing mobile companies. Every mobile designs having some additional feature. All mobiles are used for information communication only, but the thing is
Yes.
that one will be having an camera pixels, it may be a clarity, and then slide changer. Very first design of Sony Ericsson, they have added the option of slide changes, and each and every mobile having some features. Based on the feature only, they are claiming the novelty and they are protecting their invention. So
Okay.
if it is a earlier Indian inventions are, they are asking where is the product, then only we will give an IP. But nowadays, 99 percentage of inventions are modified version of the existing one. So we need to find out the minute particle where we have to be add the invention in that mobile models. So this is what a one case study which I want to give it to you to understand about the
Sure.
patented inventions.
Sure. Probably I will have a follow-up question in the same regard, that again, VectoScalar Technology is a software company where we are building mobile application and similar software application for our clients. Now, again, I would like to understand that in case of mobile, still there is a physical device which can be created.
Yeah.
So, do we have patents only for the software, where a software application is being created and we can have the patent for that?
Uh, yes, I could say yes for the before 10 years. But nowadays, they are giving little modification. So software programs and the software related patents are filed only in US, but in India protected only the utility patents are going for an grants. It's 50 percentage will get an a grant in software field. But if it is end with an product, you are creating and coding, and then with the process of a certain algorithm, the algorithm can access the device. So that is exactly on the automation in automotive industries or the robot. So even rovers, drone technology, all will be having an integrated circuits of the automation as well as the coding part based on the AI ML. Nowadays, there people are very much interested to learn about the AI. So the thing is that what feature and the delay timing, the existing program and the current program will be differentiated. So that differentiation might be an delay time, or it might be an added feature to increase the fast and response. So like that, you have to be integrate with the existing device what you have done. So that
Okay.
part only you can claim as a patent. You should not claim the product, but it is for the feature is for that X product.
Okay, got it, got it. Thanks for explaining it in detail. Before moving forward, I see a question coming from one of the viewers. So, Simple Setia is asking, what opportunities do you see in the field of IPR? You are so closely associated with this field. So, what are the new opportunities that are coming up here?
The new opportunities are many things are there. See, when we were started in the college, at the time no one is educating us. There is an opportunity in intellectual property rights, right office. But the thing is, IP office now they are creating an central government examination kind of a things that is called under CGPDTM. So this 5 years once they are conducting an examination. That examination called patent examiner. So if you interested in this IP field, I'm requesting the people those who are at the age of, especially the women category, they are extended up to 40. And if it is a men, it will be always 31 years. And you can opt the paper. There is no relevant to your technical field. It is only English and general knowledge, especially on the reasoning and aptitude. So those who are well in this category, they can apply for an examiner. So IP, if you are interested in IP, they can you can move for patent examiner. There are only four offices in India, so they will be locating in any places. So self study is enough. This I got to know at the year of 2018. So no, I met one of my colleague, and he is a patent lawyer, and he cleared a patent examiner. I asked a simple question: how do you enter this examination? So I saw advertisement in CGPDF, PDTM. Then I applied simply. There is only one round. There is no interview round also. Paper 1 and paper 2 one day. You can clear it means 50 marks. 50 marks it is easy to clear, because nowadays all the people are very smart than of us. So definitely they will be clear this examination. In the year of 2016 to 18, only 500 people are selected, but the last attempt which they have shortlisted up to 2500. So now all the new peoples are recruited again. We will be wait for another 5 years. This is one thing. Or they don't want to go for a government employee, and I want to be a lawyer and freelancer. So want to become a freelancer, no need to join in any other companies and all. So they can apply for a patent agent, and they can clear the examination. For the past 5 years, they are conducting yearly twice the exam, but this year they are conducted only one time. Maybe the plan may change. Increasing number of lawyers, they are reducing the attempts. So this is patent lawyer. You will certified getting one lawyer ID, and with that lawyer ID you can proceed. And the recruitment for the lawyers are, software industries are recruiting for the intellectual property cell itself, and minimum salary package they started giving from 2 to 3 3 lakh per month. So this is an added advantages might be which I got to know. If they are making the service up to 10 years, and they can move on directly to the IP office also. So if he's 10 years privately working as a patent lawyer, they will be patent attorney can apply directly to the IP office. So these are the opportunities are there relevant to IP. Interested
Sure,
started
sure.
in the year of 2019.
Okay. So as you just described in detail, that there are opportunities for people to take this up as a career option where they can get into IPR field,
Exactly.
and the benchmarks are pretty doable, so that one can comparatively easily get into this field. But as we all understand, that this field being complex in the manner that mass education is required, and then there are difficult and complex situations that arises. So one has to keep upgrading their skills and knowledge to understand that
Yes.
how things are working and how things are changing. That's definitely is the need of the hour. And I think probably the content itself, one should as a startup founder, one should definitely refer to that content itself, so that they understand that what are the different types of patents that are there, or the copyrights, what is the difference between a trade secret or a patent. So that whatever invention that they are going through, they can always try those things with their hand. So thanks Dr. Agalya for explaining this process. And I'm sure in US especially, I was following few companies which are into innovation. Probably their primary business is research and innovation, where they create patents and then probably get those fees, the recurring fees to for companies who want to use those innovations, and they get, so it's, that itself is a business, as I understand, right?
Yes, 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 yes. So now
Okay.
government is making many kind of rules. An educational institution, if you are a small entity, you can join with the educational institution and the individual. Individual must be a female. If they are there, then definitely it will be a nominal price. That is an application fee. They reduced up to 1,600. So if it is entities alone, the fees is different. But if it is a educational institution, now equal to an individual only, they have reduced in the last year itself.
Okay, so as I can hear that uh, women's are getting better advantage into the field, and
Exactly. So in
there
this
are certain other
2023, there
opportunities.
are 1 lakh patents are granted. So majority of patent inventions are from women and women inventors.
Okay, that's interesting, and that helps the system overall. So I hope, Simple, your question is answered. Thanks for asking the question. Let me go to the next question. The next question is coming from Shubham Gupta, who is asking, can you share your expertise on how intellectual property right intersect with the rapidly evolving landscape of technology? Because especially the recent technology like artificial intelligence and machine learning, blockchain is coming up. So where do you see how things are evolving, especially in those technology areas for the IPR?
So in this question, it is little critical to answer because intellectual property rights are useful to the society. So many people are thinking that they will be modifying the feature and we will get the grant. But the grant is a certificate for up to 20 years. They are renewing it, but they cannot able to transfer the technology to the industry. So keeping the empty paper, it is useless. So what we need to do, the very good point they have highlighted here, it is a landscape. So you, before going to apply for an patent, you must to evaluate your technology where it will be exactly matches. If it is a AI or deep learning or machine learning, whatever it might be, it is a programming platform. So in that programming platform, we may change the coding style, but the application should be useful to the industry or not. You must to be do the analysis, that we can call it as a market analysis. So they have to do it prior.
Okay, so definitely some we need to do those, that kind of market analysis, that how that application will be useful. So it's not specific to technology,
Market
but more on
analysis,
the industry
yeah.
usage.
Market analysis not only for the company, they can use it for the intellectual property rights also.
Okay, okay. Thanks for sharing that information. And Shubham, I'm sure your question is answered. Thanks for asking the question. Before taking up other questions, I would like to ask one question here, that what are the common challenges related to IPR and how to resolve them? There must be some common challenges. So give some thoughts on that part.
Uh, Common challenges are, though we have an invention, when we apply for an examination of any kind of application, so we will be always ready. The FER report will be says 99 percentages objection only. But the first person, when we are the first attempt, when I saw my FER, I just really fed up. So what should I do for the further process? So I thought of seeking lawyer. So the thing is that we requested with the ex company lawyer. So I thought they are excellent and they will be legally supporting us like that. But the thing is that legal person knows only the terminologies of rules and laws. But as we the technical analysis, we the one to explain in front of the examiner. That should be very much clear. So 99, seeing the 99 percentage of objection, we could not have any kind of a fear. First, read who are the objected patentee and the inventor. Read their article very much clear in a different each and every line, and what they have done, where we missed it, but our invention is incorporated with their invention or not. That you can highlight. So the ex inventor has done this methodology, but not at all feasible for this solution. That's why our invention came into the picture. Like that, we can mark it. So it is a comparative analysis. Each and every question, we need to be highlight the stated inventor objections and along with our explanation. If it is clear, then definitely examiners are satisfied with the answer. They will be directly giving a grant. So they will call for an interview and directly with the Skype, and they will ask you for a solution if you have any programming part or any model you launched. So I showed my model, and the model is used in my vehicle itself. So after seeing that one, so that controller is very much satisfied. So I'm the last person as he's about to get retirement. I'm the last person getting granted. And he said, is societally you created a novel feasibility, so you can go for a technology transfer. So this is my uh, case study which I taken from my patent.
That's
So thing is that
that's a
seeing an
interesting.
objection, don't get any fear. So you should go through line by line and give the explanation. This is what the answer from my end.
That's a positive feedback in the manner that one might see that they have made some payment to the lawyer and they will take care of the things. But as you explained that it's always your responsibility, you need to look at each paragraph and provide all the details and think
Yes.
that you are
This
the
is for
owner.
an individual
Obviously,
account, but
yeah,
I'm not say lawyers are not doing that much things. But in case of hearing,
yeah,
technically we are good. But if legally, if you wanted to get that patent, should be granted. Sometimes examiners will refuse your application. So in that case, legally, which law, which rule has to be supported. So we need to be get the lawyer support at the time of hearing.
sure, sure. Thanks, Dr. Agalya, for answering that. Let me take next question. The next question is coming from Aman Chadda, who is asking that how can individuals and organizations stay informed about changes and developments in IPR laws and regulation? Because if things are changing at such a fast pace, so are there any good websites to follow or some Twitter handle or email list that one can subscribe for?
No need to go any other third party website. So Indian government is always providing an it is a transparent information in their website itself. So IP India is sufficient. So
Okay.
it will be
So
disclosing all the inputs and whatever the changes of amendment, and is there any modification of the fees and fee structures and any case studies. So everything will be available even for an preparation of patent examiner as well as a lawyer examiner. They are producing sufficient material in their website itself.
okay, and new grant information, if we want to study that, probably want to study some 100 recent patents and how they were granted. So is that documentation public and we can go and study those
Yes,
documentation?
it is in public. It is in public, but we need to be go through the website in a clear way and filed information that will be in a secrecy box. So they won't be disclose any filed information, but published information it is available for the public view, and granted information, infringement case, or if any refused application and abandoned application, all the informations are there. That is an effective website. If people they may make use of the website frequently, definitely they will be get to know all the kind of information. So I
Sure.
always weekly once every Friday they will be updating the information. So Friday sitting in front of the IP office website, and I need to collect all the information circulating to my subordinates.
Okay, that's very good to see that Indian government is that proactive nowadays, that things are updated at the fast level, and one need not go through any other channel, as you just explained. And the official website itself is good resource of information, providing all the details. That's a
Yeah.
very
So
useful insight
if
for us.
now they are including for if it is granted, you are unable to do an technology transfer. So if you go directly to the IP office, they are supporting. There will be a separate branch for the technology transfer officers. They will be connecting with us. But one thing is, we will make our presentation will be very clear, and who are the manufacturers are there inside India. We need to collect the industry list. Then we can directly go to the IP office. They will be supporting to us.
Okay. That's useful information. I have next question coming from Nikhil Agarwal. So, what would be your advice to new founders who launch their startup to develop an app ideas? So, new founders who are starting startups and launching ideas.
So new founders, I request you can always go for an successful founders what they did it, and the failure founders where they missed it. All the stories are available. So first of all, read the stories and how much duration they are taking it. If the application is nowadays, the best example is the Uber and Ola services. So how they promoted their application. So they are not concentrating on manufacturing and car or the hotel management. They are investing only for the application that will be user friendly. So those features are there. So they have the other companies. If anybody else is doing the same kind of an application, first of all, go through entire details, and they need to be do the survey, and from the analysis only they need to go for an starting up their business. So nowadays, many tools are available to landscape their business. So if we invest 1 rupee or 1 crore, and what will be the outcome of after 5 years, whether it will be a profitable business or it is a loss. So where we are going to be reach out the break even point under, there will be ready-made tools are available with the websites. They can try for the before going to be invest money to the business. They can invest their time and brain for searching out these data in the websites. So
Okay.
open tools are available.
So that's broadly for the business success. In addition, any quick suggestion for or guidance for founders in regard to IPR, that trademark, when to file trademark, when to file copyright and trade secret, and when to file patent? Is there any
I
quick handy?
request yes, beginners, they could have take one of their friend who knows the IP along with the
Okay,
team member. So they will take care of the entire things. This is what the suggestion for the newcomers,
sure, sure. Thanks,
and
thanks.
especially in the startup.
Thanks, Nikhil, for asking the question, and thanks, Dr. Agalya, for this insightful delivery. I have a last question that is coming from Shrey Kalra. So, how do IPR laws vary across different countries, and what challenges does this create for multinational companies?
This is a law level. Nothing is different. Country wise, it will be different categories are there. One minor variations are there. So if you want to, which country you are going to be do it, so you have to be read the manual of the rules, and there will be a patent manual for every country. So every country, there will be an agreement between all the 158 countries in the Paris Agreement. So they have to be start from that. What is Budapest Treaty? What is Paris Agreement? What are the laws are available for India, US, Europe, Canada? Like that, they need to study the manual, the difference. So, for example, in Indian patent, they are not at all accepting the claims writing in the way of European style. But current trend, you can use the legal law of European government as provided under the section 10 rule 14 like that. So you have to be state I'm using, it should be and the claims are written in a European IP law as per the section of 10 and 11. So they will be agreeing. So last, if wherever the country we can take it, but the style should be explainable.
Okay. So that
Challenges
is
are
for filing.
very
Yeah.
less. Challenges are very less current years and all. But earlier it was very difficult. They are restricting only one country patent law. You cannot take it for the other country.
So does it mean, as you just mentioned, that by taking a patent in, say, we file a patent and it is granted, so does it directly mean that it is granted for all the countries that comes 158 countries, or you have to go out and take up
No,
different
no.
grant for different countries?
If suppose a patentee is from India, so file first your country, then you can go through an PCT. So patent cooperation treaty, they are accepting for the other countries and all. So you in the application itself, you can provide the tick mark, then they will take it for the international level.
Okay, so the application itself has a process,
Yes,
but
it is there.
depending on the use case or the individual instance, one may have to file to other treaties or the countries if there is any objection or there is anything. One can or need to find and work with other countries as well.
Yes.
Okay, okay, thanks. Thanks, Dr. Galia. I think while we are running out of time, probably any last message for you to our audience that how they can uh, create and because still, though you explain in very beautiful manner that one can innovate and there is no boundary that one has to come from the relevant experience only, but still probably the cost or for some other reasons people are not coming in that many numbers. So any last message for our audience that what they should keep in mind or how they should start?
The last message for every individual, I'm requesting observe yourself and what kind of problems you are facing. Go for an IP right, start a business, definitely it will be an great wonders. You be the multi businessman in future. I'm a failure
Thank you.
entrepreneur, but I started my company in 2009. I ran the company up to 2016. But though I'm not being very well in that age, I started a business. But now I learned many things. But the thing is that I'm finding my break even point. When should I get the profitable business point exactly? So if it is people are ready to invest for a businessman, no need to work under anybody's control. So they have to be find out the problem with them itself.
That's an inspiring statement that one has to find the problem that they can solve and start working on the solution. And in that process, if they can identify that it's a novel idea that they are working on, they can leverage the IPR rules and regulation so that they can secure their patents and get benefit out of it.
Exactly.
Yeah. Thanks, Dr. Galia, for taking out your precious time to be on VectoScalar Tech Talk show. Thanks again.
Thank you, Mr. Vikas, for inviting me, and thanks for your background organizers who have supported for you for the entire events. Thank you.
Thank you very much. And thanks to audience for always being such a nice guest and viewer at this program. In case you are watching this episode later also, you can type your comment, expression, appreciation in the chat box below, and we'll be taking up those and answering those questions even later. And keep watching VectoScalar Tech Talk, our weekly podcast show where we share technology insight. Thanks again. And till we meet next time, have a nice day ahead. Bye bye.
Thank you, everyone, for the patient listening.